In this session, we are going to see about the sellers and buyers' rights and liabilities before the sale and after the sale. Section 55 of the Act deals with this. First, we will take the sellers. Seller's liability, seller's duty before the sale. First duty is a duty of disclosure. Section 55, subsection 1, clause A says that if there is any defect in the property, you have to inform to the buyer. Any material defect. Any material defect means if the buyer is in knowledge of the defect, he will not buy. That is a material defect. If it is known to him, he will not buy the property. That is material. Immaterial things need not be disclosed. Minor things. He has to inform the buyer the defects which the buyer has which the buyer cannot discover the defect. For example, there is a notification for acquisition of the property by the government. Buyer has no knowledge. Then seller has to inform him. Or if the property is this person's property, but he has already given the right of way to another person, that should be informed. If there is any other encumbrance, that should also be informed. Another person has issued a notice, or electricity dues are pending, they have issued a notice. These are things are defects. This should be informed to the buyer first. In one case, Sukhdev Kaur versus Gurdev Kaur, in this case, notification was not issued, but the proposal was pending with the government. This person has not intimated the buyer. In this case, it was held there is no need because no notification was issued. The seller is under no obligation to tell that defect to the buyer. Next is to produce the title deeds. It is a duty of the seller to give to show the title deeds to the other person. These are the title deeds. Based on this, I have got a right over the property. That should be given to the other person. At the convenient time and place, at the seller's place or the buyer's place, here the buyer should have the right to, should have the facility. He should be shown the title deeds. The buyer should have the facility to see all the documents. Next is 58 to 1C. Answer all the questions raised by the buyer regarding the property. Based on the title deeds, he may raise some questions. It is the duty of the seller to clarify all these things. Answer all the questions regarding the title of the property. Next is execution of proper conveyance. This is once you pay the money, you have to pay. But that is also shown as a duty, shown as a liability on the part of the person selling. Once the money is paid, you execute to proper conveyance. Where to write, when to write, all these things by mutual discussion and mutual agreement. But he is under obligation to execute to proper deed conveying the right over the property. Next duty is to take care of the property and the title deeds. Take care of the property and the title deeds. For example, if a person has given advance and he informed the seller, I will come after 3 months and we will execute the document. In between the 3 months, the person has to take care of the property. If it, for example, if it is a mango garden, if he is not watering the plants, then the plants will go dry and asset value will go down. There is an obligation on the part of the seller to take care of the property. Same way, he has to take care of the title deeds also. He should return it, he should give it to the other person on execution of the sale agreement. Take care of the property and the title deeds. Next is pay outgoings. Pay all the charges on the property till the date of transfer of ownership. For example, if there is electricity bill, if the documentation is on 15th, any expenses up to that 15th should be paid by the seller. This is section 55 1 clause G. Next we will see the liabilities of the seller after the completion of sale. After the sale he has to give the possession. Once the ownership is transferred, he is under an obligation to transfer the possession also. Hand over the possession. How to transfer the possession, how to hand over the possession is by mutual agreement they have to decide. This may be tangible or intangible, the immovable property. For example, if it is a land, you can show it from tomorrow you take care of this land. If it is a house, they will give you the key of the house. If it is a intangible immovable property, for example, a right to catch the fish, then he can say from tomorrow you catch the fish. That is, they decide how to give possessions. Next, section 55, subsection 2 says there are some implied covenants for the title. That is, if a person is selling the property, there is an implied covenant that he has a right over the property. This need not be expressly mentioned in the agreement or anywhere. It is an implied condition that the person selling is having a right over the property and he is conveying the right to the other person. He has an absolute right over the property. This is section 55, subsection 2. Next, another condition, section 55, subsection 3. Duty to deliver the title deeds on receipt the price. Once the price is received and the documents are executed, this person has to hand over the title deed to the other person. He has to execute the title deeds and he has to give it, and if there is any backdated title deeds, he has to transfer it to the other person. There may be a condition when he transfers only a part of the property. He is having 10 acres. He is transferring only 2 acres. In that case, he can keep the parent documents with him. Only 2 acres, he will write to the document the title deeds and give it to him. Parent document will be this seller. If in another situation, if the property is sold to 3 or 4 persons, in that case, the person with the higher value should receive the title deeds. If it is a 10 acre, one person is buying 3 acre, another person 1 acre, another person 1 acre. In that case, the person who has purchased 3 acres will have the right to receive the documents. Whoever receives the document has an obligation to show it to the buyer at his expenses at the places agreed upon by the parties. For example, the person who is buying the property is going for a bank loan, they may require the original document to be seen, the backdated documents to be seen by them, by their advocate. Then the buyer will come with that advocate, inspect the documents at the place of the seller or at the place of the person who is holding. This is the duty of the seller to hand over the documents to the other person. Now, we are going to see the rights of the seller. Seller's right before sale. Before sale, we have already seen the seller has to pay all the expenses up to the date of transfer. Same thing, if there is income, the seller has the right to receive all things. For example, if it is a house he is selling on the 15th of one month, January, up to 15th of January, he has to clear all the tax payment, electricity charges and all. Same way, if it is a rented house, he has a right to receive rent up to 15th of that date. He has a right to receive the income, rents and profits till the date of execution of documents. Next, charge over the unpaid price. For example, if the seller has conveyed the title over the property, after the buyer promised that I will pay the balance amount after 6 months. In that case, the seller has a right over the property, charge over the property. In case the person is not giving the money, he can proceed against the property for the unpaid amount. Property 15 lakhs, 10 lakhs paid, he agreed to pay another 5 lakhs after 6 months. The seller will have a right over the charge over the property for that 5 lakhs. It is like an auctionable claim. He can transfer this charge to the other person also. If the buyer, without paying the 5 lakhs, has transferred the property, in that case also, the charge of that unpaid seller will move along with the property. Whoever buys, the charge will be attached to that property. Next is, we will see buyer's liability before completion. We have seen the seller has a duty to disclose the defect. Here, the buyer has a duty to disclose anything which will materially affect the value of the property. For example, the buyer knows that one bus stand is coming near the property. The seller is thinking that it is an agricultural land, I can sell it for 1 acre, 1 lakh. But the buyer knows that another project is coming very near to this, the land appreciation will be there in another 2 months. Then he has a duty to disclose it to the seller. Like a seller has a duty to disclose the defect, here this person has a duty to disclose anything which will affect the value of the property. There is a case of Samos versus Griffiths. In this case, the seller, the lady, old lady, she is thinking her right is defective, not an absolute title over the property. She is thinking that her right is with some encumbrance. But the buyer knows that her right is absolute right, no encumbrance. In that case, he should have informed the lady, your right is absolute right, there is no encumbrance. He should have informed it. He has not done that. He has purchased for a very meager sum. They went to the court. The court held that he should have informed that her rights are absolute rights. Next is a duty to pay the price. When seeing the duties of the seller, we saw that he has to execute the sale deed. Now, here there is a condition that he has to pay the price, or both. He has to pay, he has to execute the sale deed. Buyer's right before completion of sale. What are the rights for him? If he has paid anything price before sale, he has a charge over the property. For example, 15 lakh property, he paid 10 lakhs. He informed the seller, I will come after 3 months, I will pay another 5 lakhs and we will execute the sale deed. The 10 lakhs, he has a charge over the property. In the same way, if the property is transferred to some other person, that charge will be attached to that property also. Now we will see the liabilities after completion. What will be the liability? That on completion of sale, the ownership is transferred to the buyer. If the ownership is transferred, the risk will also be attached to the property. He has to bear all the losses after the sale. For example, a person has sold the house, documentation over, he has not taken the possession, key was with him. He told after a month I will take a possession, I will see some auspicious day and take a possession. In between something happened, flood has come or property damaged, only the buyer has to meet that loss, he has to bear the loss. Same way he has to pay all the outgoings. From the date of sale, he has to pay all the outgoings, that is electricity charges, taxes, everything he has to pay. In one case, a special officer was Nesco versus Raghunath Paper Mills Limited. In this case, if the company went on a liquidation, that property was sold, a person purchased the property and he has applied for electricity. The electricity company informed this person there is a due, there are some dues are there, you have to pay, then only we will give electricity connection to you. Then it went to the court. The court held that arrears of electricity dues of the erstwhile company, the new purchaser is not liable. But in another case, Carbon Resources Limited versus Assam Electricity Regulatory Commission, it was held that the person has to pay the bill, old dues, and he has to recover it from the seller. Next, the benefit of increment after the sale will go to the buyer. That is, when the risk is attached is also moving along with the property after the sale, any benefit will also be attached to the sale. After the sale, if there is any benefit, that will go to the buyer. For example, from the 15th, he has a right to recover the rent. From 15th, he has a liability to pay the taxes, electricity, everything. Same way, from 15th, rent is due, then he can collect the rent from the tenants. In the next session, we will see another topic.